Welcome to the lesson. I am Jiajia. I offer lessons in criminal law and medical law for undergraduate students and master students in law school. Today in the lesson, we will talk about cybercrime in China. Harmful cyber activities pose an increasing threat to cybersecurity. If you just say this is a harmful cyber activity, several laws can be applied. For example, Public Security Administration law, Network Security law, tort law, and of course criminal law. I want to help you understand, in China, what kind of harmful cyber activities can be a crime or deserve criminal punishment. First of all, let's have a brief look at the historical development of cybercrime in China's criminal law. China was grounded on October 1, 1949. After that, for 30 years, there was no book called Criminal Law in China. In this period, the grounds for fighting against the criminals were specific regulations. We can read examples. There are regulations for suppression or counter-revolution, regulations for corruption, and regulations for disturbing the monetary order. China's criminal law was promulgated firstly on July 1979. It took effect on January 1, 1980. But in the Criminal Law 1979, we cannot find an article on cybercrime or computer crime. If we remember the social background, then we can easily understand it. Around the year 1977, the microcomputer revolution started in the United States. At the end of the 1970s, the personal computer had not yet become a common item in China. But as a result of the microcomputer revolution, the personal computer became a mass-market consumer electronic device, and it was also introduced into the Chinese market in the 1980s. Then the first criminal case of misusing a computer was reported in 1986. In this case, the actor fraudulently withdrew money from the victim's bank account in an ATM. The ATM was a computer terminal. So people can say, in this case, the actor used a computer as a tool. And in the second part of the 1990s, the computer virus cases also began to emerge in China. The economic and social situations changed radically. In 1997, China's criminal law was all-round amended. The amended criminal law defined 3 types of cybercrime in 3 articles. They are Articles 285, 286, and 287. Entering the 21st century, the number of Internet users in China rapidly increased. China Internet Network Information Center issued the 37th report in December 2015. This report said the number of the Internet users reached 688 million, and the internet penetration rate went up to more than 50%. In other words, more than half of the population uses the internet in China. Meanwhile, harmful cyber activities rapidly evolved and brought a greater threat to cybersecurity, citizens' rights, and economic order. Against this background, the legislator amended the Criminal Law 1997 two times, in 2008 and 2015. As a result of those amendments, more harmful cyber activities were criminalized, and the punishment became harsher than before. After we reviewed the history of cybercrime in China, we can say that the involvement of criminal law in this field became active step by step. I hope now in your mind you have already had a general picture of the historical development of cybercrime in China. Next, we will continue to analyze the elements of harmful cyber activity to be a crime. This is the main task in our lesson. No penalty without law. Its Latin version is nulla poena sine lega. It is a principle in criminal law. It means that a person should not face criminal punishment except for an act that was criminalized by law before they performed the act. So to apply criminal law to punish harmful cyber activities, the legislator used the elements to define cybercrime, and the judge should reasonably interpret them. I mentioned above, there are 3 articles of cybercrime in the Criminal Law 1997. So as below, I want to guide you to understanding elements of cybercrime based on those 3 articles. Article 285 defines the first category of cybercrime, called offenses of intruding into computer systems without permission. Whose computer system is an important element for applying the criminal law? To answer this question, we will introduce 2 paragraphs in Article 285. They are paragraph 1 and paragraph 2. Paragraph 1 was written in the Criminal Law 1997. The 7th Amendment to the Criminal Law in 2009 added a new paragraph, paragraph 2. With this new paragraph, the legislator broadened the scope of punishment. Let's study the 2 paragraphs one by one. First, it is a computer system with information concerning state affairs or construction of defense facilities or high-level science and technology. We can call them significant computer systems. Intruding into significant computer systems without permission was criminalized in the Criminal Law 1997. Intruding without permission is serious enough to deserve punishment. The actor should be sentenced to no more than 3 years in jail. Which computer system can be a significant computer system as prescribed in Article 285. This is an important issue in the enforcement of criminal law. I read some examples. The first example is the information system of the Credit Reference Center of the People's Bank of China. The People's Bank of China is the central bank of China. It is responsible for carrying out monetary policy and regulation of financial institutions. It is a cabinet-level executive department of the State Council. So intruding into the information system of its credit reference center is a crime. The second example is information system for national-wide professional and technical staffing qualifying exam registration. It is managed by Ministry of Human Resources and Social Security. It is also under the State Council, responsible for national labor policies, standards, regulations, and managing the national social security. Besides the computer information systems on the national level, the computer systems of local governments are also significant computer systems in the practice of law. Is intruding into private computer systems also a crime? This is the next question. Before the 7th Amendment to the Criminal Law in 2009, the answer was no. But after that, the answer is yes. But the act of intruding in itself cannot constitute a crime. Two more requirements must be met. First, the intruder must obtain data in the computer information system or control the computer system. Second, the circumstance must be serious. For example, in one case, the intruder obtained 370,000 items of personnel data information and sold them. In another criminal case, the actor made brute force attacks against the victim's computer and then infected his computer with a virus to control the computer information system. In the second case, the actor intruded by a brute force attack. What is a brute force attack? It is an attempt to discover a password by systematically trying every possible combination of letters, numbers, and symbols till you discover the one correct combination that works. The last question about the application of Article 285 is, if the accused knowingly provides an intruder with the programs or tools, should he be punished or not? The answer is clear. Yes, he should be punished. But on what conditions? First, the accused action here is aiding an intruder. If we regard the intruder as a principal in the cybercrime, the accused as an accessory can be guilty of aiding the intrusion when there is conspiracy between the principal and the accused. We can call it a combination of a principal and an aider. Its legal ground for punishing an aider is Article 27 of the Criminal Law. An aider can escape from the punishment in the following three situations. The first situation is one-sided assistance. It means the aider knowingly helps the principal intruder, but the intruder is ignorant about the help from the aider. The second situation is the lack of evidence of the conspiracy. The conspiracy might have happened, but it cannot be proved beyond any reasonable doubt. The third situation is the principal offender was arrested before attempting the commission. In a combination of a principal and an aider, whether the aider is punished depends on whether the principal is punished. In short, in the three situations mentioned above, there are legal loopholes. The Seventh Amendment to the Criminal Law in 2009 solved the legal loopholes. According to the newly added paragraph 3 of Article 285, anyone who knowingly provides the programs or tools used for intruding into or controlling computer systems should be guilty. Here, the act of aiding an intruder in itself is a ground for punishment. In other words, the aider is regarded as the principal offender in the crime as prescribed in paragraph 3 of Article 285. In this sense, we can say, paragraph 3 of Article 285 is a ground for broadening the scope of punishment. Article 286 defines the second category of cybercrime, called offenses of illegally making damages. The act of making damages is not enough for punishment. To be a crime, making damages must let the computer system fail to work normally. Or cause other serious consequences. The punishment can be up to 5 years in jail. If the circumstances are extremely serious, the punishment can be more than 5 years in jail. How to understand making damages is very important for applying the criminal law. Making damages is banned in the following three situations. In the first situation, the target is a computer information system. Making damages means unauthorized deleting, altering, ending, or interfering with the system. For example, the offender accessed the computer web server of the victim company and made changes to the NGIX configuration and the web server. In other criminal cases, making damages was done by deleting and altering the backstage database of the online-to-office e-commerce platform, or attacking servers by using large flow. There is also a cluster of criminal cases of misusing Apple platform security. If you are using electronic devices made by Apple company, you must be familiar with its security system. A passcode is an important way to protect your iPhone, for example. If you enter the wrong passcode on your iPhone lock screen too many times, your iPhone will tell you it has been disabled. Unfortunately, ample platform security was misused by the offender. He accessed the system of the victim's iPhone and changed the username and password. In this way, the offender could remotely lock the iPhone. His purpose was to blackmail the victim for money. To unlock the iPhone, the victim was ordered to give money. Even the victim did not follow the order. The accused could be charged with cybercrime. In the second situation, the target is the data or application programs installed in or processed and transmitted by the computer system. For example, the offender wrote a computer program and used this program to access the computer system of a driving school. Then he altered the data concerning the hours of his studies. In another criminal case, the offender discovered the flaw in the network payment platform. He transferred only 1 yuan to his account on this platform, but he altered the data. As a result, the amount in his account became 50,000 yuan. In the third situation, the offender can make damages by producing and propagating a computer virus to make the computer system work abnormally. Producing does not necessarily mean producing by the offender himself. For example, in one case, the offender ordered software from another person and sold it online. This software could be used for damaging or interfering in voice functionality. Propagating can be selling online, or selling online and remote installing, or invading inspection systems and uploading the virus onto the internet, or sending a toy horse via SMS text message. The last question about Article 286 is the ISP's criminal obligation. What is ISP? ISP is the abbreviation of the Internet Service Provider. The Internet Service Providers can be entities or individuals. The services they provide can include as below: network access, computing, storage, and dissemination services, or information network application services, like information releases, search engines, online gaming, online streaming, or public services provided by the use of international networks, like e-government, traffic, energy, water resources, education, healthcare, and so on. Even if the ISPs do not carry out an illegal action, they can still be blamed because they tolerate the dissemination of illegal contents on their platforms. Those illegal contents can include, for example, child sexual abuse materials, child pornography materials, pirated materials, speeches for abetting others to do bad things, or fake news. The question is whether the ISP's omission or removal of illegal contents can be a crime. Before the 19th Amendment to the Criminal Law in 2015, the answer was no. At that time, ISPs could only be involved in a civil lawsuit. But after that, the answer is yes. The 19th Amendment added a new article. The article is Article 286A. According to this new article, the ISP can be charged at a criminal trial if the following 4 requirements can be met. First, the ISP fails to perform the duties of information network security management. The source of those duties is not the criminal law. Article 21 of the Cybersecurity Law is an important ground for those duties. Second, the official department responsible for the oversight and management of the network security has already ordered the ISP to take measures in order to remove illegal contents. The second requirement tells us that ISP's intention must be the direct intention. Third, after being ordered, the ISP still refuses to take measures as expected. Fourth and last, as a result, the ISP's omission causes serious consequences, like the spread of a large number of illegal contents, the leakage of users' information, the loss of evidence in a criminal case. The punishment can be up to 3 years in jail. The ISP commits a crime by omission. The omission, objectively speaking, became the assistance in another person's commission of crimes. If there is a conspiracy, the ISP could be guilty as an accessory. But in most cases, the ISP's assistance is based on the omission without prior conspiracy. In this case, the ISP can only be punished according to Article 286A. In this sense, we can also say that this article broadened the scope of punishment. We already introduced the crimes of unauthorized intrusion and cyber attack. Harmful cyber activities also include crimes committed via the Internet or through communication information technology. Here the computer system is used as a tool. This is the third category of cybercrime, as prescribed in Article 287. When writing this article, the legislator just listed einige common or more harmful offenses, like financial fraud, theft, corruption, embezzlement of public funds, and stealing state secrets. But the application of Article 287 is beyond those offenses listed. Please take note that Article 287 does not provide for a new definition of a crime. It is a reminder. That is, although some offenses occur online, the application of provisions in the criminal law has no change. Then a new question arises. Does that mean old wine in a new bottle? My answer is no. First, although the application of provisions will not change, the constructive elements of those provisions need to be reinterpreted. Where the characteristics of online crimes should be taken into account. Nevertheless, to what extent is a reinterpretation possible? The interpreter must keep the principle of legality in mind at all times. As a result, reinterpretation cannot solve all issues. Then, for harmful cyber activities, criminalization or increasing criminalization through legislature may also be necessary. Let's consider a new question. Can a preparatory act deserve punishment? For example, to commit fraud, the actor makes preparation for the commission by setting up a website or using email or text messages to trick the potential victims into giving money. At the stage of the preparation, he is arrested. In this situation, should he be punished or not? In the preparation stage, there is usually no imminent danger to the interests protected by the criminal law. In other words, the preparatory act creates only abstract risks to the legal interests. So even if the criminal law would intervene, the punishment would be reduced or even waived, according to Article 22 in the criminal law. If the crime determined is a serious crime, like murder or terrorist offense, its preparatory act deserves punishment. But, for example, if the actor prepares for an offense of property damage, its punishment could be waived. We can say that the judges have a great discretion as to whether to impose punishment and to what extent to mitigate them. But this situation has been changed by Article 287A in the field of cybercrime. Article 287A provides the legal ground for criminalizing a preparatory act. Those preparatory acts can include setting up a website or mail list for committing fraud, transmitting criminal methods, making or selling prohibited or controlled items, or spreading illegal information related to drug production or drug trafficking, or prohibited or controlled items like guns or pornography items, or spreading information for taking illegal activities like a fraud. As long as an actor took the actions mentioned above, he could be sent to a criminal trial based on Article 287A. It means that the prosecutor does not need to prove whether the actor has already initiated the crime determined, like fraud, drug trafficking, or dissemination of child pornography items. In this sense, we can say the application of Article 287A broadened the scope of punishment and set limitations on the judge's discretion. The punishment can be up to 3 years in jail. The last group of acts has a German name called Beihilfe durch neutrale Handlungen. Neutral means that the behavior usually occurs in social life, is harmless in itself, and even brings about social value when it is a business behavior. In this sense, the behavior is far from the topic of a crime. Nevertheless, Beihilfe means that such a behavior objectively makes the commission of a crime easier, or provides conditions for it. Let's read an example. A person carried out a business for online services. He was a law-abiding businessman. But in one case, he knew that his acquaintance determined to commit telecommunication fraud through a phishing site, but he still sold him domain names and helped to analyze data. His purpose was not to assist in the fraud, but to earn money by providing online technical services. In such a case, is his knowingly providing online technical services a crime or not? Of course, if there was a conspiracy from the beginning, the provider of online technical services could be punished as an aider. But in the case of Beihilfe durch neutrale Handlungen, there is no conspiracy, and the helper did not participate in the determination, organization, or preparation of the crime either. Here, Beihilfe is in nature not a violation of the criminal law, till it is objectively linked to another's crime. Due to the characteristics of Beihilfe durch neutrale Handlungen, whether or not it should be punished is in a dispute. Nevertheless, in the field of cybercrime, the dispute was stopped by Article 287B. This article was ended by the 19th Amendment to the Criminal Law in 2015. This article says that it is a crime to knowingly provide technical support or material help to cybercrime. Technical support refers to internet access, server hosting, web storage, or communication transfer, and etc. Material help means providing help like advertising, paying bills, and etc. All those supporting activities are daily services or customary services, though they could be called Beihilfe durch neutrale Handlungen. According to Article 287b, if related to cybercrime, Beihilfe durch neutrale Handlungen can also be a crime. This article further broadened the scope of punishment. Cybercrime is a form of high-tech crime. To commit a high-tech crime, multiple offenders usually need to partner in the commission. As a result, cybercrime and organized crime are combined. We call it organized cybercrime. I want to introduce a typically organized cybercrime called the crime of database hits and capture verification. The first case in this form was dealt with by Yuhang District Court of Zhejiang Province in 2018. In a crime organization, offenders play different roles. Some offenders play the role of a hacker, and their contributions are to hit the database. Hitting the database is a hacking technique for defeating a cipher, usually in the form of a username and password. Many netizens use the same usernames and passwords for different websites and applications. Why? I think many people do so in order to make usernames or passwords easily remembered, but they let their usernames and passwords in a more risky situation. That is because once cracking the password for one website or application, hackers can succeed in logging into other websites or applications. To get usernames and passwords, the hacker can try hundreds or even millions of likely possibilities. This is hitting the database. The purpose is to get the correct combination of username and password. Then the hacker sends or sells the victim's username and passwords to his partners. But after typing in the username and password, usually the intruder must bypass capture verification. Capture is the abbreviation of completely automated public Turing test to tell computers and humans apart. I think netizens must be familiar with it. It aims to determine whether the user is a human. Bypassing human capture is a must before computer intrusion. So in an organized cybercrime, the organizer usually hires many workers to deal with capture verification. In an organized crime, there are organizers, principals, accessories, instigators, and aiders. If the conspiracy can be proved, they take criminal obligations based on their contributions. But if the conspiracy cannot be proved, the preparatory act or assisting act could also be penalized based on specific provisions, including Article 285, Paragraph 3, Article 287A, and Article 287B. In the end, we draw a conclusion. In China, cybercrime has a short history, but since 1997, especially within the recent 10 years, lawmaking and rulemaking activities are very active in the field of cybercrime. We can see the tendency of criminalization and increasing criminalization. Basically, there are three types of cybercrime in China's criminal law. They are computer intrusion, cyber attack, and computer as a tool. By amending the provisions concerning cybercrime, the legislator enlarged the scope of punishment. The interesting part is the legislative techniques the legislator used. The first technique is to alter the constructive element. In 1997, the victim computer system was limited to significant computer system. But since 2009, a private computer system can also be included. The second is to criminalize the omission of the ISP. It can be regarded as one-sided assistance through omission. The third is to criminalize an assisting act, a preparatory act, and thirdly, by Hilfe durch neutrale Handlung. If we briefly describe the new changes in China's criminal law in the field of cybercrime, we can see a change from post-punishment to forehand prevention. And from the protection of public interests to the protection of public and also private interests.